Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
We will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addicts live stream in their courtroom.
Fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican po, he's verbal sloppy.
That's literally not true.
I didn't ask you to interrupt me.
Is that correct?
Oh, for Trump's sake.
All right, I can hit that button. Welcome back to the Court of Public Opinion. I am the Recovery Addict. Thank you very much for joining us this afternoon as we are going to begin digging into the latest filing from the Tyler Robinson defense team. Utah pressing charges against Tyler Robinson for the death of Charlie Kirk, and they are going for the death penalty, but today's filing might change that. We'll dig into that just a little bit in just a moment here. Thank you, Loves True Crimes, for being first here in chat. Saying hi, welcome. I'm in the wrong spot. I'll fix that. Loves True Crimes, I believe this makes you a repeat offender for being first in chat. We're going to punish you for that crime. Everything IP related worldwide is your responsibility. There we go. All right. Whew. Nice. All right. It's bad if I already got a cough. You've got 41 pages to read. 41 pages is a lot, but we will get there. We're going to dig through this. It's not all. With all filings, there's like padding. The front page barely has anything on it. The last couple of pages,
take a short break.
A lot of them are exhibits and things like that. So we're going to be good. But we are going to, let's see here. Let me keep this front and center. Oh, not that one. This one. Where's the window? Document 11 is the one we're looking for. Oh, got it. It was already up. That's the one I needed. All right, we're going to pull this up on the screen so you can see everything. And let me know if you can read this here in just a second. How does that look to everybody? All right. You see Kathy Nestor's name right there at the top. See what you're seeing. Yes, I'm covering part of it, but I'll scroll. It's all right. I'll scroll. Buckle up. Buckle up. We've got a little bit of light reading. This is not time to sleep. This is time to get your notepad out and start taking notes because this case will be on us before you know it. This Tyler Robinson thing. Dramatic reading of the filing incoming. So buckle up. We'll get this all set here. Where can you... There we go. All right. We've got all the defense team on the top here. Richard Novak, Michael Burt, Stacey Weiser. Defendant Tyler James Robinson preliminary hearing brief. We have a preliminary hearing coming up soon. It's coming. In the 4th Judicial Court, Provo Department in and for the County of Utah, State of Utah, the State of Utah plaintiff versus Tyler James Robinson, defendant, and it's Judge Graff, who's turned out to be a very methodical and thoughtful judge in this situation, but has also created a lot of problems for himself with how he has set up the ground rules for this. Table of contents. It starts with a table of contents. I love it. We've got the introduction, the argument. We've got the state has not met its burden. We've got matters of law regarding the burden at parts A, B, C, D, D1, D2, more matters of law. Part E, plenary of jurisdictions support Utah's narrow construction of KGRD. We'll get into KGRD a little bit. We'll find out what that means. Count 6 must be stricken because the evidence is not established. Mr. Robinson's statement to Mr. Twiggs was intended to obstruct the investigation. The violent offense committed in the presence of child must be stricken for the same reason. We've got all sorts of stuff in here. They've thrown all the spaghetti at the fan, and we're going to go through this. This is look at their citations. I think what was wrong with the my YouTube live stream was it wouldn't let me have the word death in my title, so I couldn't say death penalty. I had to say DP. but then I changed it, and then it worked. We've got a lot of citations, a ton of them, lots of case law, and I like that some of them are, let's see, we've got Arizona, Florida, we've got some Utah cases. I like that. Those are good. Okay, we'll dig into some of these possibly. Then we've got the federal statutes, Utah statutes, other authorities, Arizona. Why is Arizona on here? Like, they have authority over this case? No jurisdiction. No jurisdiction from Arizona. The Utah rules of criminal evidence, judicial rules, constitutional provisions. Whew. All right, buckle up. Buckle up. On September 16th, 2025, the state charged Tyler Robinson with the capital offense of aggravated murder. Aggravated is in italics. That's what we're targeting here. Aggravated means death penalty eligible and other lesser offenses. The state had over 10 months to investigate the shooting death of Charlie Kirk and to develop legally sufficient evidence that Mr. Robinson knowingly created a great risk of death to another other than Charlie Kirk and the defendant. The sole aggravator alleged in the information, which in theory exposes Mr. Robinson to the potential punishment of death. That's the Utah Code. That's the law. The state's presentation of its evidence as to this alleged circumstance in aggravation at the preliminary hearing in July 2026 wholly fails to carry its burden of proof. The state's failure cannot in any manner be attributed to any orders by this court limiting its presentation, nor does it fall within Rule 1102C1, because the state's presentation in support of this aggravating factor was not based upon hearsay evidence, nor did this court exclude any proffered expert testimony. In fact, the court did not exclude any evidence on this subject, and it did not limit the amount of time available to the state to present its case. Yet, the state has failed to establish probable cause that the shooter knowingly created a great risk of death to another other than Charlie Kirk and himself. The state is required as a matter of law to show more than a possibility that someone else may be killed by defendant's conduct. Rather, there was a high probability of that result and that the defendant knew of that high probability. And where the state has overwhelmingly failed to make this showing, it asks this court to expand Utah's narrow construction of the great risk of death aggravator using decades-old cases from another state jurisdiction. It's interesting that they say that because they're about to use another state's jurisdiction. Binding constitutional precedent, both under Utah law and the United States Constitution, demonstrate the state's failure here and why this court may not impermissibly broaden the scope of knowingly created a great risk of death. The facts of the law require this court to strike the sole aggravating factor. If they strike the sole aggravating factor, you can't reach death penalty. That's why they're going after it, and they're going after it hard. Here's their argument. The state has not met its burden to show probable cause by relying upon hearsay deemed reliable by a rule in violation of Mr. Robinson's constitutional rights and separation of powers principles. Does this sound familiar? I think it sounds familiar because we've already fought this battle once in this trial, and the judge has already ruled on it. And if I remember correctly, the defense has already appealed that ruling, and that was also ruled on. So we're dredging the same ditch, hoping for a different result. We're not going to get there with this, I don't think. But we'll listen to the argument and see what they say. As briefed and argued extensively prior to the preliminary hearing, and as raised as a continuing objection throughout the preliminary hearing itself, the state's extensive use of hearsay deemed reliable by Rule of Criminal Procedure 1102 violates Mr. Robinson's constitutional rights and separation of powers. This is the same argument they raised, and it was shot down. And that's how they open this. What this tells me is they don't have a case here. This is weak. Weak sauce, as we like to, as Ian would probably say. It's weak sauce. There's no spice here. There's no punch to it. It's a strong argument when they made it the first time, but it was ruled on, and they were overruled. This court may not bind over Robinson based on the state's evidence consisting primarily of hearsay that has not been assessed for reliability. Remember, Utah allows hearsay in these preliminary hearings. It's so they don't have to bring everyone in. An officer who took someone's statement can say what that person said. That's the reliable hearsay. Now, that can't come in trial. You can't have the officer just bring in all that hearsay and skip the witnesses that way. But in this case, where the burden is lower in the preliminary hearing than there would be in a trial, they can bring in this reliable hearsay under Utah rules. And defense is still their butt hurt over that. And they need a little bit of, what's that, Desitin. I think they need some Desitin. The preliminary... This is particularly true as it relates to the evidence cited by the state to establish identity for all the charged counts. This evidence consists largely of alleged communications between Mr. Robinson and Mr. Twiggs, alleged communications between Mr. Robinson and other individuals on the application Discord, and an identification of Mr. Robinson from UVU surveillance footage. This evidence came from, or became presumptively admissible through, a recorded interview between Utah County Attorney's Office and Lance Twiggs. A witness the court would not allow Mr. Robinson to seek to subpoena from another state to testify at the preliminary hearing. Remember, defense wanted Twiggs there in person. They did not want these recorded statements that are so damaging. He may testify more reservedly than he was open to the police in the original interview. That might have been beneficial to Mr. Robinson if that happened. The state said, no, we're not going to subpoena him from out of state for your preliminary hearing. We're just going to use what we have on record already from him and take that evidence. And they're very upset about that. Let's see. The state has failed to prove probable cause by reliable evidence that satisfies each element of the charged evidence. This court must decline... it should be a 2 in there. Decline to bind over on all charges. That's, I think, the second typo. I think they had a positive instead of a negative in the sentence earlier. As a matter of law, the state has not established and cannot establish probable cause to support the aggravator that the shooting knowingly created a high probability of death to another individual from the single shot from a high-powered scoped rifle from a rooftop vantage that hit the intended target. They're saying no one else was in danger. It was a precision shot. We'll see. Mr. Robinson is charged with aggravated murder pursuant to Utah Code 765-202-2A3, which requires the state to prove that the actor intentionally or knowingly caused the death of another individual. I think we've got that part. Under circumstances where the actor knowingly created a great risk of death to another individual other than the deceased individual and the actor. Okay, have you ever volunteered to be the person with the apple on your head for the bow and arrow demonstration? That archer is incredibly good. He's very, very good. But most of you would not volunteer to be the put it on my head, I'll stand there person, because you know that you are in great risk of death. Right? I think it's pretty easy to say that with somebody sitting, what was it, 144 yards away? I don't remember what the distance was. It could have been 300. I don't know. That many yards away and surrounded by people and a crowd in front and people in back and all around, that even though you could shoot the apple off the head, it still puts other people at risk. What happens, for instance, if the ammunition you have, the bullet you have, has a lower powder measurement than it's supposed to have? What if it's a squib load and the bullet comes out at a deadly velocity but different than what you were expecting, and drop happens much faster because it's not moving as quickly? What happens if there's a bird that flies through and you hit the bird, it deflects the bullet? Lots of things can happen. There are risks and dangers here. Anyway, but we'll go into this a little bit. The state has not shown and cannot show probable cause to support this single alleged aggravator. The defendant may only be bound over for trial if the prosecution produces evidence sufficient to demonstrate probable cause that the charged crimes were committed and the defendant committed them. There's case law with State v. Murphy, Ramirez, Utah Criminal Code, everything else. There's lots of citations there. This threshold requirement is intended to ferret out. I like they used ferret out, because ferret is an animal. And a ferret is really good at, it's like a mink. It's like a mink going after a rat. It will find it in the hole and drag it out and eat it. ferret out groundless and improvident prosecutions, relieving the accused from the substantial degradation and expense incident to a modern criminal trial when the charges against him are unwarranted or the evidence insufficient. Then going back to Ramirez on that citation. As discussed further herein, the state's burden requires them to provide evidence to support a reasonable belief, and when the evidence, considered under the totality of the circumstances, is wholly lacking and incapable of reasonable inference to prove some issue which supports the prosecutor's claim, this court must decline bindover. The bindover they're talking about is the judge who is going to issue his ruling about bindover on this. So this is, let me step back a little bit. This document is the written closing argument for the preliminary hearing which we watched. Normally there would be the preliminary hearing, which is like a mini trial where we say, this is all the evidence the state has against you. And sometimes defense can say, well, we have this evidence. And then the judge makes a decision and says, I see there's sufficient evidence, under the burden, under that lower standard of proof, there's sufficient evidence to take this to trial. We're going to let the jury decide. That's what we're doing here. But the defense has 41 pages of closing argument to say, this is why you shouldn't. This is why you shouldn't bind him over. And if they don't bind him over, they release him. It's done. It's over. Not sufficient evidence, case dismissed. They're going to bind him over. But let's see if they are able to get the charge lessened, the aggravator removed, so that they can get rid of the death penalty. That's all they want. And I imagine if they get rid of the death penalty, he'll plead guilty. All right. As discussed further herein, the state's burden requires them to provide evidence to support a reasonable belief, and when the evidence, court must decline bindover. The court is empowered to make reasonable inferences from the evidence presented. However, the court may not engage in speculation. The United States Constitution and the Utah Constitution both require courts to construe alleged aggravators narrowly. The 8th and 14th Amendments to the United States Constitution do not permit imposition of the death penalty in an arbitrary or capricious manner. Great words. The objective of the law is to require that the discretion of a sentencing body in a capital case be carefully channeled by standards designed and applied to ensure that there is reasonable distinction between those murder cases in which the death penalty is imposed and those in which it is not. So this aggravating factor, it should be notable. It should be significant. It's not just, and other people could have been hurt like that. So we'll see how this argument fleshes out. In order to bring meaning to this long-standing principle, the United States Supreme Court has explained that the Constitution requires courts to narrowly construe aggravating factors in order to avoid overly broad interpretations that violate 8th and 14th Amendments. The United States Supreme Court has twice examined the KGRD aggravator at issue here. KGRD. In Gregg, the case law Gregg, the court upheld the inclusion of KGRD as a statutory. Let's see, what's that? For brevity, Mr. Robinson refers to the aggravator as KGRD throughout, and that's going to be. I need to see what it spells out. Knowingly created great risk of death. I think that's what we're talking about. Knowingly created great risk of death. KGR. Does that sound right? Can we all agree that KGRD means? Can you holler up to Mrs. Ray to check the door real quick, pretty please? I'm the only one here. Do you want me to turn and check the door? Yes, is somebody here? Amber, are you here? Hold, please. 2 seconds.
Take a short break.
All right, hang on. I had nothing to do with this. I have no idea what it is.
It's bigger than me.
We're going to continue this in a minute on KGRD. Someone sent me stuff from Walmart. I've got some spicy pickles, wicked sliced pickles.
In front of the Walmart.
I have inflatable bats, helium-filled balloons, the number 7 for how old my channel is today.
The zombie apocalypse may be
Gets
upon
better.
us.
Oh my goodness. A birthday cake for the channel with sprinkles. Thank you very much. And a gallon of milk, because you know I can't eat cake without milk. That is awesome. That is awesome. Had I known this was coming, I would not have gorged myself on yummy Thin Mints.
Happy birthday. You look good.
Thank you. Amber, did you arrange this? Oh, my goodness. Okay. The milk has to go in the fridge. What does the cake say? It doesn't. Does the cake say anything? It says vanilla celebration cake with vanilla icing. Keep refrigerated. Freshness guaranteed. I will say that in the heat of the weather out there, the sides are peeling off. The frosting's peeling off. But it says nothing on it. Was it supposed to say something? Dang it, return it. It's fresh till the 20th of this month. Not the cake, the label. Vanilla celebration cake. Okay, Amber, hang on one second. Amber, are you there?
I'm here.
What are you doing to me? I'm trying to focus and read 41 pages of a very interesting argument from the Tyler Robinson defense team.
I can't tell you how difficult my morning has been to focus
Happy
on
birthday.
anything
You look
other than
good.
doing this daggum order. Which was not my idea, by the way. I will let the person who had this magnificent thought out themselves.
You sent inflatable bats to my house? You know I have children, right?
I did it on purpose, and there's 4 of them. The balloons were supposed to have already been inflated.
They're in the package still. It says it's 28-inch in air or helium filled. This is a 16-inch air filled balloon. Yeah. Oh, that's why we have a separate mod chat.
The cake was supposed to say !HBD. You look good. Love your mod team.
Thank you. We got the full Walmart doesn't care treatment on that one. That is awesome. Okay, I'm going to put this in the fridge. All the frosting has melted off. Like just in the heat, it just sat out there for just a few minutes, and all the frosting is now off the sides. It was on a minute ago. So it's still hot in there, I think.
It'll
still
taste the same in your bowl upside down.
Yeah, of course. All right. We're going to be right back. We're going to read this in a minute. I have to put the milk in the fridge and the cake in the fridge. I'll be right back.
Take a short break.
Happy birthday. You look good.
All righty.
In front of the Walmart.
Headphones on. Let's get them working again. There we go. I'm going to keep the pickles out here. for an emergency purpose in case I need them. All right, we were talking about Kate. Thank you, by the way. I have absolutely amazing mods. You guys are fantastic. Appreciate that. The channel is 7 years old. We've only done true crime stuff for 3 years and I think 9 months, 10 months. But I did start the channel 7 years ago today. So, all right, now I'm out of breath running around. Hang on one second. I just threw my water bottle lid, which means I'm going to spill. Don't know where it went. All right, so we're talking about KGRD, means knowingly
Happy birthday.
created great risk of death? Is it death? Knowingly created great risk of death. Yes, KGRD. You can't just make up your own acronyms. It's not like you're the military. You're not the Air Force. You're the defense in a murder trial. You can't just make up your own 4-letter acronyms because it's convenient to you. But all right, thank you, Francis Fitzgerald, for the gifted membership. Winter Libby, member for 33 months. Happy birthday, RA and friends. Thank you. It is the channel birthday. We'll eat this. Year 1 metal detecting, year 2 and 3 interpretive dancing, year 4 jail time, year 5, 7 true crime. Close. All right, Winter Libby, thank you very much. You are an OG at 33 months. Thank you. All right, now we need to focus, guys. I was doing so well. I was like, this is going to be a professional, polished video. It's just straight Tyler Robinson for those people who just can't get enough of the case. And then that happened. Okay, so knowingly created risk of death. Loves true crimes. Thank you once again. Another huge support super chat. Thank you. And good luck with owning the internet today. All right. The United States Supreme Court has twice examined the knowingly created great risk of death aggravated issue here. In Gregg, the court upheld the inclusion of KGRD as a statutory aggravating circumstance. They said, while such a phrase might be susceptible of a overly broad interpretation. Oh my goodness. Loves true crimes. Thank you. Look what you started. Kim R. Thank you as well. Another huge, generous super chat. Thank you. Y'all are too good to me. I appreciate that. While such a phrase might be susceptible of an overly broad interpretation, the Supreme Court of Georgia has not so construed it. Why are we talking about the Supreme Court of Georgia? The only case in which the court upheld a conviction in reliance on this aggravating circumstance involved a man who stood up in a church and fired a gun indiscriminately.
You are banished from the state of Georgia.
I am banished from the state of Georgia. The only case in which the court upheld a conviction in reliance on this aggravating circumstance, the knowingly created a great risk of death, involved a man who stood up in a church and fired a gun indiscriminately into the audience. On the other hand, the court expressly reversed a finding of this great risk when the victim was simply kidnapped in a parking lot. Okay, so we know that if you just stand up in church and close your eyes and just shoot wildly around you, that qualifies as knowingly created a great risk of death, but just kidnapping one person does not, because it has to create great risk of death to someone other than the person you kidnap. Hey, hello, who's home? Hey, bud. That looks awesome. Let's see. 428 U.S. at 2202 or 202-03, the same year, Profit versus Florida, the court upheld the use of KGRD as an aggravator based on the Florida Supreme Court decision in Alvord v. State, which also construed KGRD narrowly. Of course, they're going to pick all the cases that construe KGRD very narrowly. They don't want their instance where Tyler Robinson is alleged to have fired a high-powered rifle over a crowd into a group of people to shoot one person to count as creating risk for anyone else. In Alvord, KGRD was obvious because the defendant murdered 2 of the victims in order to avoid a surviving witness to the first murder. So you saw what I did. I have to kill you now. You know too much. That's a great risk of death. In each of these cases, the court considered whether the statutory aggravating circumstance was too vague and overbroad to pass 8th and 14th Amendment muster, and in each, the court upheld the aggravator because the state's highest courts had narrowly construed them. The principle that the death penalty may not be wantonly and freakishly imposed, that's in quotes, which means that's a quote from the Supreme Court or some other ruling, requires the state to channel the senator's discretion by clear and objective standards that provide specific and detailed guidance. We don't want wantonly and freakishly imposed aggravators. Lucy Liu, member for 26 months. OG, 26 whole months, plus probs, some with you amazing mods, friends, and Scott, you too. We've made it through a lot of highs and lows. I'm feeling blessed, as am I. Thank you very much. And Lucy Liu, it would not be the same without you here. Thank you so much for 26 months. Wanton and Freakish was the working title for the podcast. Hey, it's still available, I think. All right, a footnote here says that in Lucas v. State, it's another Florida case in which the state Supreme Court upheld a KGRD judgment where the defendant had engaged in a raging gun battle. Raging gun battle. I'm loving these words. Anyway, so the citation was admitted for that one, but as a result, the state's definitions of its aggravating circumstances, those circumstances that make a criminal defendant eligible for the death penalty, therefore play a significant role in channeling the senator's discretion. Thus, this court must narrowly construe that knowingly creating a great risk of death consistent with the Utah Supreme Court guidance and strike that, let me say this again. This court must narrowly construe KGRD consistent with the Utah Supreme Court guidance and strike the aggravator. So they're going to say, we believe the Utah Supreme Court says it should be very narrowly applied. This one doesn't apply. You have to strike the aggravator. If the court says that they'll do that, the death penalty is off the table. Utah Supreme Court decisions narrowly construing the KGRD aggravator require this court to strike it here. They want to get it out now. This is not something you want to leave up to a jury, right? Because that's anything can happen with the jury once it gets in their hands, right? They can come to any conclusion they all agree on. And they want the court to rule it out here, so the jury doesn't even have that option if we get down, to trial down the road. Over the course of the past 50 years, the Utah Supreme Court has had at least 3 opportunities to carefully consider the knowingly created great risk of death aggravator. In doing so, it has identified a minimum set of factual circumstances which must be present in order for the aggravator to be applied in a constitutionally valid manner. Mr. Robinson addresses here the 3 decisions by the state's highest court which, when applied to the facts presented here, compel this court to strike the alleged aggravator because those constitutionally required factors are not present. They need to have a strong argument here. They have to win this one. This is a must-win argument. Those Utah Supreme Court cases are its decisions in State v. Sosa Hurtado, that's a 2019 case, and 2 long-standing decisions in State v. Johnson, which is from 1987 and 1977, the year I was born. They are addressed below in chronological order so that this court can see how the doctrine which this court must apply in this case has evolved to require as a factual matter that where one or more firearm is used in a homicide, the defendant actually discharges multiple rounds, hitting or killing individuals other than the murder victim in a series of events. They're saying he had to have fired multiple times. I'm not sure if that's the strongest argument because a high-powered round can kill 2 people. People can be, a bullet can pass through one person and a second person and cause a lot of damage. And we're actually, the fact that it didn't in this case is more of a surprising factor than the possibility that it could. All right, as a matter of fact, let's see. These actions are concatenating series of events which the Utah Supreme Court first referred to in its 1997 decision in State v. Pierre, and then reaffirmed in its decision in Sosa Hurtado 2, that may lead the court to conclude that the conduct alleged created a high probability that someone other than the victim and the defendant would be killed. I'm curious if any of the cases they're citing have a situation where the defendant committed the crime, right? Killed someone, because it's murder. It has to be a murder. It's an aggravated murder. From a distance, while the victim was in a crowd. Because that's basically the scenario we have with Charlie Kirk's death. At a distance, high-powered rifle, so the ability to kill at a distance, and doing it while they're surrounded. 1 year after United States Supreme Court decisions in Gregg and Profit, the Utah Supreme Court considered the application of KGRD in State v. Pierre. In Pierre, the defendant was convicted of 3 counts of capital murder. Pierre and 2 co-defendants tied up 5 individuals in a business establishment and forced them to drink liquid Drano. Okay, is this the hi-fi murders? Is this the hi-fi murders in Ogden? Do you guys... Oh my goodness, this was the talk of... When I lived in Utah, there was a hi-fi shop, which was a high-fidelity stereo. It was a shop that got robbed, and I'm not sure if they were all employees, if there were people... They did force people to drink Drano. They kicked a ballpoint pen through somebody's ear. It was crazy. If you want to Google that a little bit, the store is still there. The hi-fi shop is still there. But I'm wondering if that was the case, because I can't think of any other one where they were forced to drink liquid Drano. Pierre eventually shot each of the 5 victims in the head. 2 of the victims survived, 3 did not. In upholding the application in Utah's KGRD aggravator, the Utah Supreme Court found that the evidence... It sounds like Ogden. Yeah, it was like, yeah, that checks out. That's Ogden for you. 2 of the victims survived, 3 did not. In upholding the application of Utah's knowingly created great risk of death aggravator, the Utah Supreme Court found that the evidence fully sustains that the killing of the 3 victims and the creation of a setting of great risk of death to 2 surviving victims occurred within a brief span of time in which were formed a concatenating series of events. They want the series of events because in Tyler Robinson's case, they want to say that the only event that occurred that was a problem was the pulling of the trigger, which was a one-time thing. And so there was only one person at risk, which was the person that the gun was pointed at. I can see their argument here, and it might hold sway. The judge would listen to this, I think. A decade later, in State v. Johnson, the Utah Supreme Court held that the KGRD aggravator did not apply to the circumstance where the defendant attacked a husband and wife with a shovel, killing the man. Okay, these cases make Utah look bad. It's a great place. It really is. I'm sorry. We don't regularly force people to drink Drano and attack married couples with shovels. It's usually not what happens. When the defendant delivered the injuries to the man, he was on the other side of a warehouse from his wife, and there were shelves between them. The court noted that KGRD properly applies to situations in which the defendant kills his victim in a manner by which he knows he is gravely endangering others. Was it upheld in this one? The court held that KGRD aggravator did not apply. So it did not apply when you kill someone with a shovel on the other side of the room with shelves in between the warehouse. The court noted that KGRD properly applies to situations in which the defendant kills the victim in a manner by which he knows he is gravely endangering others. The Johnson court also held that the state produced no evidence indicating that the wife was placed at grave risk of death by the defendant's battery of husband, nor did it produce evidence indicating that the defendant knew that his conduct towards husband placed wife at great risk. In Johnson, the Utah Supreme Court further explained how KGRD aggravator is applied. It wrote, Section 76.5.202.1c properly applies to situations in which the defendant kills his victim in a manner by which he knows he is gravely endangering others. I'm not sure if we have to use the defendant knowing. I guess we do, because it's knowingly. The K in KGRD is knowingly. So the defendant has to know that it's dangerous to other people. I think the state might be able to counter this by arguing that Tyler Robinson knew it was dangerous and practiced shooting so as to try to to focus his attack on the right person, to make sure he hit the person he wanted to instead of somebody else. I think that would be an argument that could hold up in court. Interesting. All right. Defendant was convicted under a similar statute to this section, but also includes language concerning killings in public places when he assassinated his victim by opening a fire in a crowded church. That's the crowded church one. And so just spraying bullets around you in a crowded church, even if you hit your one victim, does count. In State v. McMurdy, defendant shot his intended victims in a crowded bar. Cert denied. Defendant made his claim his victims lie on the ground and shot them with a rapid fire from a rifle. What state was that in? I don't know that one. Defendant shot the victim in a crowded auditorium. Okay, so some of these... So it properly applies to situations which the defendant kills his victim in a manner which he knows is endangering others. So all these ones would apply, saying this is a case where knowingly creating a great risk of death. We have open fire in a crowded church, shot in a crowded bar, a bunch of people lying on the ground and just spraying them with rapid fire from a bullet, and shot a victim in a crowded auditorium. I think the closest one we have to this is a crowded auditorium. They literally were in an outdoor auditorium when this happened, although it would be considered that he was on stage and not in the crowd. A closer look at the cases referenced by the Utah Supreme Court in Johnson demonstrates that the fact patterns which it views as authorizing the KGRD aggravator do not exist here. In Chenault v. State, the defendant was convicted of aggravated murder after shooting multiple individuals inside a church. There, the defendant fired multiple shots from 2 pistols, killing 2 individuals and injuring another, and randomly shooting into the congregation. This is the church one. The jury recommended the death penalty, finding the aggravating factor of knowingly created a great risk of death to more than one person in a public place by means of a weapon or a device which would normally be hazardous to the lives of more than one person. Weapon or device which would normally be hazardous to the lives of more than one person. I think they can argue that because he had multiple rounds in the gun. I think that might be an argument point. But he didn't shoot more than once. So can you charge somebody with something you think he was going to do? Maybe not. In State v. McMurdy 3, the Arizona Supreme Court issued a remand for resentencing because the trial court did not adequately consider mitigating evidence in the course of imposing the sentence of death. What does this have to do with it? The facts underlying the conviction were that after McMurdy and 3 victims engaged in loud discussions in a bar, he went to the parking lot, retrieved a gun, and then returned to the inside of the bar where he shot 3 victims, killing 2 and wounding a 3rd. During sentencing, the trial court found that the defendant knowingly created a grave risk of death to persons other than the murder victims. The Arizona Supreme Court agreed because the evidence of the trial established that the Ranch House bar was crowded the night of the killings and there were from 5 to 9 other people in the immediate area of the victims when they were shot. This is going to be a factor, the immediate area. How much distance was between Charlie and the closest person? And I think we're going to get into the line of sight argument. I saw that in the table of contents, and we might get that a little bit. There were children there. We're going to have that discussion as well in the presence of children. That's also included in this document. We're only 7 pages in. We have 41. So we've got a lot of that. Loves True Crimes, thank you very much once again for your support. All right. The other Arizona Supreme Court decision cited by the Utah Supreme Court in Johnson is State v. Doss from 1977. This is going back a few years. I should know. That's how old I am. In Doss, the Arizona Supreme Court upheld the application of the KGRD aggravating factor. That means that they could use that. The defendant shot the victim in a place crowded with college students. Oh, that sounds really familiar. And one of the defendant's shots did, in fact, wound one of those students. In the course of conduct, the defendant emptied his revolver. Under these facts, there was no question KGRD applied. The last out-of-state case cited by Utah Supreme Court in Johnson is a 1981 decision of the Louisiana Supreme Court in State v. Saunier. The jury found to be true the aggravating circumstance that the defendant knowingly created a great risk of death or great bodily harm to more than one person. The Louisiana Supreme Court had previously determined that this aggravator is established when the defendant, by a single and consecutive course of conduct, contemplates and causes a great risk to more than one person. That, I believe, shooting over a crowd counts as that. In Saunier, the Supreme Court found that the execution of two victims lying side by side with 6 rapid-fire rifle shots, clearly amounts to a single consecutive course of conduct by which defendant contemplated a great risk to more than one person. In each of these cases, relied upon by the Utah Supreme Court in Johnson, the defendant fired multiple shots. It says filed. I should say fired. Right here. It's a little. It's just typo number 3. It's okay. I've missed a couple. In each of these cases relied upon by the Utah Supreme Court in Johnson, the defendant fired multiple shots from a firearm in close temporal and spatial proximity to other individuals. And in each of these cases, individuals other than the murder victims were, in fact, injured. In 2019, Utah Supreme Court revisited the standards for the imposition of the KGRD aggravator in Sosa Hurtado. The defendant was charged and convicted of aggravated murder for shooting and killing Stephen. Just prior to shooting Stephen, the defendant fired his weapon at a second individual, Isabel, which resulted in injuries to Isabel. The shooting occurred inside a smoke shop. Sosa Hurtado entered a smoke shop and pulled an assault rifle from his jacket. He must have had a big jacket. Sosa Hurtado first fired a shot at Isabel that missed but shattered a glass case, causing injuries to Isabel. After he shot at Isabel, Sosa Hurtado turned towards Stephen and fired a shot, hitting Stephen's hand. Stephen fell to the floor. Sosa Hurtado then shot Stephen 2 more times, killing him. Big footnote here. Arizona eliminated its KGRD aggravator in 2019, amending their laws regarding the death penalty. The lack of KGRD is now a mitigating factor in Arizona. That is, it is mitigating if the defendant could not reasonably have foreseen that his conduct in the course of the commission of the offense for which the defendant was convicted would cause or would create a great risk of death, causing death to another person. So it's become from an aggravating to a mitigating side. They argue it backwards in Arizona. That's interesting. Okay, so Stephen died, unfortunately. The Utah Court of Appeals had, below, examined the sufficiency of the evidence supporting KGRD, reviewing Utah case law, specifically State v. Pierre and State v. Johnson, and persuasive authority from other jurisdictions. The Utah Appeals Court determined that judicial decisions about whether this aggravator applies are often influenced by 3 main factors: the temporal or chronological relationship between any actions the defendant may have taken towards the third party and the acts constituting the murder. I think clearly it has to be the act constituting the murder that will qualify in this case. The spatial relationship or proximity between the third party, the murder victim, and the defendant at the time of the acts constituting the murder. The greater the distance between the two, I would say the higher the risk to a third party, because the less variation in aim would be necessary. It would lessen the degree of off-target aim required to shoot somebody else. Because if you're 5 feet apart, you point at each other, it looks like this. If you're 200 feet apart and you move a degree off, you miss the person. But at 5 feet, you still hit them. So the distance does play in. Let's see. And 3, whether and to what extent the third party was actually threatened by the assailant, either by direct threats or by indirect means, such as the risk of stray or ricocheting bullets. I think the state wins that argument as well, even though I don't think we have anything in text messages or citing any animosity from Tyler Robinson towards people who were in attendance. I believe it was all directed at one individual, but just the rounds that he was using, the high-power 30-06 round, has a very high likelihood of ricocheting and injuring other people. So I think they're going to get it on that front. Let's see. Utah Supreme Court endorsed those factors. In its own analysis, the Utah Supreme Court embraced principles from KGRD and decision in New Jersey State v. Prince. In Prince, the New Jersey court found the following to be necessary in order to support a KGRD finding. The relevant facts to be considered must include a knowing or purposeful state of mind vis-a-vis. Love new words all the time. The creation of great risk of death. That there be a likelihood or high probability of great risk of death created, not just a mere possibility. I would say it's there when he fired the bullet. Because it's bullets ricochet. Bullets pass through things. High-powered bullets do so more than a slower, smaller bullet. Everyone was surprised that it didn't do more or go out and get the bullet somewhere else and stuff like that. I think the state's going to win this front. In upholding the jury's verdict in the Utah Court of Appeals decision affirming the verdict, the Utah State Court found that a reasonable jury could easily find that the identified factors support the conclusion that Sosa Hurtado caused great risk of death to Isabel during the murder of Stephen. Sosa Hurtado fired at Isabel seconds before shooting. New Jersey, here's another footnote, New Jersey abolished the death penalty in 2007. They're just inserting these like, Utah, you don't have to do this. In 2007, prior to abolition, New Jersey's version of the aggravator required the commission of the murder. The defendant purposefully or knowingly created a grave risk of death to another person in addition to the victim. So we've got Isabel, he was fired at seconds before shooting Stephen. He shot at Stephen when Isabel was close by, and he specifically acted with the intent to harm or kill Isabel. In doing so, the Supreme Court endorsed the concatenating series of events formulation in its first identified in Pierre. In order to satisfy the aggravator, there must be acts in a series that are linked together in a meaningful way. I don't know if the acts have to be in and of themselves deadly. The acts could possibly include the dry runs, the scouting run, the stop at the turning point booth for information about when he was going to be there and where he was going to be. I think the state might be able to argue that the efforts that Tyler Robinson allegedly took ahead of the shooting, before it happened, the planning, the positioning, can count as that to show that there's a series of acts that led to a single moment where multiple people were in danger. Such a link between the acts may be established based on the defendant's intent and knowledge of the risk on the endangered person's proximity and time and place to the murder. The Supreme Court found the shot at Isabel alone to be powerful evidence of Sosa Hurtado's state of mind toward Isabel. Next, there was a close causal connection between the shot at Isabel and the shots at Stephen because the evidence could reasonably sustain the conclusion of that Sosa Hurtado shot at Isabel to get him out of the way. Is Isabel a girl or a guy? It might have been the last name. Okay. Finally, the shootings took place in a small area where the victims were within a couple of feet when Stephen was shot. These facts led the Utah Supreme Court to conclude that the killing and the initial shot at Isabel were part of the series of concatenating events, or in other words, that Isabel was within the zone of danger when Sosa Hurtado killed Stephen. I think the couple of feet thing, if you're talking about line of sight, for camera and filming purposes, Charlie was by himself on that stage, right, under that tent. He had space around him. It was open. But I believe that some of the camera angles will show that there were people just behind the tent and around that would have been in line of sight for this. The problem being, we would have to show that Tyler Robinson knew that there were people there and he was putting them at risk. So this might. There was a solar eclipse in Iceland just now. That is awesome. Total solar eclipse. I tell you, the best thing about watching a solar eclipse, total solar eclipse, other than seeing the moon-shaped sun things on the ground as the sun disappears through the trees, is when the birds go quiet and they're like, oh, I guess it's nighttime. And then the temperature drops a few degrees. That's awesome. I hope you enjoyed it. let's see. The evidence presented by the state fails to establish probable cause as to the KGRD aggravator. Preliminary, Mr. Robinson must alert this court to a significant problem presented by the state's argument as to the facts established in the preliminary hearing. The state makes, they have facts in italics. They should have put them in air quotes. The facts established at the preliminary hearing. The state makes little effort to distinguish between the evidence it's presented and inferences it asks this court to make based upon that evidence. Rather, the state pursues an unconstitutional expansion of the KGRD aggravator up to this case and fails to distinguish reasonable inferences from speculation. As the Utah Court of Appeals explained earlier this year in State v. Murphy, a magistrate may deny bindover when the evidence considered under the totality of the circumstances is wholly lacking and incapable of reasonable inference to prove some issue which supports the prosecution's claim. This is State v. Prisby. In other words, a magistrate may properly deny bindover when the facts presented by the prosecution provide no more than a basis for speculation. The line separating speculation from reasonable inference can at times be faint. The two are distinct, though. Inference is a conclusion reached by considering other facts and deducing a logical consequence from them. And speculation entails the act or practice of theorizing about matters over which there is no certain knowledge at hand. In short, the difference between an inference and speculation depends on whether the underlying facts support the conclusion. 2026, Utah, AP 3810. Furthermore, it is not appropriate to stack inference upon inference to satisfy an element of the offense. While inferences drawn from facts and evidence are appropriate, inferences drawn from inferences are not. This is you can't, if it took an inference to get here, Bling City Jewelry, it's all cool. I love it. I don't make decisions just based on money. Thanks, though. Let's see. And when the evidence supports more than one possible conclusion, none more likely than the other, the choice of one possibility over another can be no more than speculation. The following is a recitation of the evidence presented at the preliminary hearing specific to this court's determination on the aggravator and the state's arguments regarding the aggravator, without drawing inference based upon the inference as the state asked this court to do. The afternoon of September 10th, several thousand people gathered in and around the amphitheater on the UVU campus to watch and listen to the guest speaker, Charlie Kirk. Mr. Kirk was struck by a projectile on the left side of his neck, and the injury resulted in his death. The best evidence of the events on September 10th, 2025 on the Utah Valley campus are the videos. We've got a big footnote here. The state quoted liberally from the medical examiner's report admitted as State's Exhibit 11 in its public filing, despite the exhibit not being published and medical records being categorically private under Utah Rule of Judicial Administration. This appears to be another example of the state's publicizing private information in contravention to the rules of guiding record classification. It would have been a simple matter for the state to redact this private information. This sounds like they're just upset about this. This is a document that does contain very sensitive information, and the information that Mr. Kirk's family would appreciate it not being published. We'd ask that it not be published here in the courtroom or to the camera. Wow. That's funny. State's Exhibits 12.1 and 12.4 are compilations of UVU surveillance footage from September 10th at 5:03 or 5:33, and 12.1 and 12.4. This at 5:03 of 12.1 and 12.4. Their surveillance depicts the roof of the Losi building and the walkway between the Losi building and the computer science building. Beginning at 12:15:20 p.m. At 6:18 of 12.4, that's the second video, the shooter is seen going over the railing separating the walkway from the Losi roof. Bagley said, a little guardrail probably about a couple feet high. Each of the videos then jump to 12:22:12 p.m. when a figure is seen running west across the Losi roof. At 12:22:25 p.m., the figure drops to the roof and begins to crawl to the western edge of the roof, going both south and west. The shooter reaches the edge of the roof at approximately 12:22:44, so he crawled for about 20 seconds. Although additional body positioning on the ground is visible until approximately 12:22:56. Describing evidence of prone position in gravel on rooftop. Agent Hull testified the shooter was prone for 15 to 30 seconds. At 12:23:28 p.m., the figure gets up and begins running to the northeast corner of the roof and drops off the Losi building roof to the ground. Officer Bagley observed shoe prints in the grass where the individual observed jumping from the roof. In those exhibits, they show a shooter was in position on the southwest corner of the Losi Center roof for approximately 35 to 44 seconds. We've got a buffer. Let's see. Got a bit of it. Okay. The jury in the sister trial is deadlocked. Oh my goodness. That means they're going to get a dynamite charge, and assuming it's not done in a hung jury, they're not going to retry this one. Let's see. Officer Bagley said there's a clear line of sight between the tent and the top of the Losi Center. Okay, clear line of sight does not mean no one else in danger. There's a clear line of sight between at a rifle range that I like to shoot at, between my shooting position and my target. But I don't shoot when anyone is down range, even if they're over at their target several rows over, because of the danger that it presents to them. Had I shot when someone was down there, I could be charged for creating, the KGRD. Exhibit 7 depicts the shooting of Mr. Kirk from behind the individual asking him questions. The questioner immediately prior to the shooting. This questioner is separated from Mr. Kirk by a barrier, a patch of grass of unknown dimensions, a table, and the space behind the table in front of Mr. Kirk. Mr. Kirk is sitting in a chair on an elevated platform that is centered in the backdrop. The shot occurs at 32 seconds of this video. There is one individual seen to Mr. Kirk's right and behind Mr. Kirk under the tent. This individual is on the opposite side of where the bullet struck Mr. Kirk. This video has no timestamps. Okay, that's going to be a tough video for the defense to get past if there's someone in that frame that shows they're behind next to. State's exhibit shows zoomed in portions of 12.4. It was achieved into evidence played in the court but not published to cameras. We've seen it because it was released before, but they didn't play it during the hearing. Officer Bagley testified that the Losi Center has 4 or 5 levels, with level 1 being courtyard level, and the top level has an atrium on top of it. Okay, that's information that does no good. State's Exhibit 8 begins with Mr. Kirk in the courtyard throwing hats to members of the crowd. The video has no timestamps. Beginning at 32 seconds, State's Exhibit depicts Mr. Kirk seated at the table under the pop-up tent with the same questioner visible in front of Mr. Kirk. There are what appear to be 2 security personnel in front and diagonal to Mr. Kirk, standing in the grass area by the barrier seen in Exhibit 7. The camera recording Mr. Kirk is visible above and behind Mr. Kirk in State's Exhibit 7, meaning the camera is angled downward. The shot occurs at 48 seconds in this video. One of Mr. Kirk's security guards comes into frame from the right of Mr. Kirk 3 seconds after the shot. That doesn't mean he was running for 3 seconds to get there. It might have been he was looking away, or it took 3 seconds for him to process what just happened and moved in. State's Exhibit 9 is UVU surveillance footage from behind the pop-up tent that begins at 12:21:14. The moment of the shot occurs at 2:13 in the video. Confirmed in testimony from Agent Hull, no one is immediately behind the center of the American Comeback pop-up tent when the shot occurred. It is also evident from this video that State's Exhibit 7 that no one can see through the back of the pop-up tent. You would not be able to see through it. That's important if we have to prove that Tyler Robinson knew that someone behind it was in danger. Agent Hull testified that he can't answer what would have been visible to the shooter on the Losi roof center roof. We might need to reenact. As bad as I say that, as I hate to say that, they might have to reenact this and set up the scene to using the video and basically show what it looked like, do the measurements, get the line of sight. Finally, State's Exhibit 6 depicts 22 seconds of the event from the perspective of witness AW. There's no timestamp on the video, but based on the content, it appears to be taken close in time to when Mr. Kirk initially sat on the elevated platform under the pop-up tent. The state's forensic investigator, Agent Jennifer Famuina, testified that the distance of the slope between the rooftop vantage and the pop-up tent was approximately 415 feet. Agent Famuina also testified that the elevation difference between the bottom of the amphitheater and the low-sea roof was approximately 68 feet. So a 68-foot drop and 415 feet diagonally or horizontally. It might have been diagonal. I'm not sure if that was a point-to-point measurement or if it was bird's eye looking down. The state claims it's brief that at least 2 individuals are standing under the tent where Mr. Kirk was seated. This claim is contrary to the evidence that is indicative of the state's reckless recitation of the evidence in its brief. That's just courtroom theatrics right there. Let's see. We've got the 68 feet from the drop. Officer Bagley description of the amphitheater. Finally, Agent Famuina testified that the distance without consideration of the slope between the 2 points was 410 feet. That math doesn't math. This is a squared plus b squared equals c squared thing, right? This takes us back to side angle, side, and geometry. We've got a right angle triangle, a right triangle. And it's not a 45, 45, 90. We've got this triangle where you say that the long leg of the triangle, which is the line of sight from the rooftop shooting position to where Charlie Kirk was seated, is 410 feet, while that might be the same one, approximately 415 feet. The distance without consideration of the slope between the 2 points was 410. So that's the baseline. Bird's eye view looking down, from the point looking down at the roof where Tyler Robinson was to the point where Charlie Kirk was, 410 feet. So the distance between the two would have been slightly more than that because he was 68 feet higher. A Mauser Model 98 rifle was recovered in a wooded area across the street from the northeast corner of the Losi Center where the individual ran after jumping from the roof. The rifle was chambered in a 30-06 caliber with a scope. That's actually a conversion. They convert this rifle to accept that caliber. It normally doesn't, and it's commonly converted to that. 30-06 is a common chambered, a common size for like a deer rifle, a hunting rifle. But the Mauser 98, I forget the actual size it was in, is a less common one, and it's cheaper to convert it to 30-06, and then you can shoot it with readily available ammunition. The rifle was a bolt-action rifle. In order to load it, lock it, as well as extract anything that's in it, the user has to manipulate the bolt. This means that the gun can hold multiple rounds inside it, but to shoot it, you have to load it with, first you open the bolt, which goes and open it, and that opens the chamber, and it makes those sounds, and you push the bullets down into a spring-loaded clip or magazine inside the gun, and then you have to push the bolt forward, which will grab one of those bullets and put it in the chamber. So the bullet goes in the chamber, you shoot, boom, and then you have to do that bolt again, which is going to turn and pull the shell out and eject that shell, and then you have to slide the bolt forward again, and it will put the next bullet into that chamber, and then you can shoot again. So it requires that manual action. This is not a semi-automatic where every time you pull the trigger it will shoot, and it's not a fully automatic where you pull the trigger once and it goes bam, 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 until you run out of bullets or until you release the trigger. Yes, sound effects are extra. You have to pay extra for those. All right, so it was a bolt-action rifle. In order to load it, lock it, as well as extract anything that's in the rifle, the user has to manipulate the bolt. When law enforcement manipulated the bolt, the rifle had a fired cartridge case inside and 3 unfired cartridges. That means he never re-racked the gun. So it was never in a firing condition after he took the first shot. The fired cartridge case was still in the chamber of the rifle. The video exhibits also contain a video of the individual in the state's witness identified as Mr. Robinson entering and exiting campus parking structures 4 times on September 10th, twice before the shooting, once at the time of the shooting, and once after the shooting in a vehicle is seen matching Mr. Robinson's on campus. The first entry was approximately at 8:30 a.m., with the individual's state's witness identified as Mr. Robinson returning to his vehicle approximately 9:25 a.m. Tomato Troy has paid for the sound effects. Thank you very much, Troy. Appreciate you. Let's see. Let me go back here so I can read. Agent Holt testified that during the initial visit, Mr. Robinson went to the amphitheater area and spoke to some representatives from TPUSA. TPUSA is the organization, Turning Point USA is the organization that Charlie Kirk founded, that ran. That was the company behind his appearances. The second entry was approximately at 10 a.m., and Agent Hull testified that Mr. Robinson went to Chick-fil-A in the Sorensen Center, walked to a wooded area across Campus Drive, and appears to be at the railing on the walkway between the Computer Science Building and the Losi Center roof. Mr. Robinson left campus the second time just prior to 11 a.m. The fact that he went down and talked to the people in charge of this that were putting it on, it was probably a fact-finding, information-gathering visit where he posed as someone who was excited to see, and this is my belief, where he probably posed as someone who's excited to see Charlie in person and just wanted the details of where is he going to be so I can get set up and see him. And they probably gave him that information. The state did not show footage of the individual identified as Mr. Robinson's movements in and around campus during the hearing, only the footage from the parking structures. According to Agent Holt, there's going to be a lot more footage as well. There's tons of footage. This is just the parts that are needed. According to Agent Holt, the individual he identifies as Mr. Robinson is seen walking in a parking structure in front of the Losi Center and then on a walkway between the Computer Science Building and the Losi Center at approximately 12:15. None of the footage shows the individual identified as Mr. Robinson passing by or near individuals that are clearly minors. How does one identify oneself as a minor on a college campus where early graduates from high school attend under the age of 18? Do they have a sign? Is there a special something? The blue Solo cup is the minor. Okay, yeah. They have a big M they have to wear on their jacket to let everyone know that they're a minor and not eligible for any activities that requires anything else. All right. Search was later conducted of the residence Mr. Robinson shared with Lance Twiggs. We're going to hear from him during the trial, if that happens, in St. George, Utah. In the closet on the first floor of the apartment, law enforcement found some shooting targets with perforations on it. That means bullet holes. Agent Falmuina testified that the perforations were consistent with bullet holes. The targets show perforations outside the target, closer to the target, and then even closer with the perforation in the center. This shows improved skill over time. The communications the state admitted between Mr. Robinson and Mr. Twiggs indicate Mr. Robinson's intention to kill Charlie Kirk. Quote, "I had the opportunity to take out Charlie Kirk, and I took it. There is no mention of any threat or intended harm to any other individuals." This is a point that's in the defense's favor. This court must reject the state's asserted theories as to how it has established facts supporting the KGRD aggravator because it has failed to establish the facts that are constitutionally required. The state offers two interrelated theories of KGRD that fail to conform to the criteria established by the Utah Supreme Court, criteria which, if not met, render application of the KGRD aggravator violative of the U.S. Constitution. Each is deconstructed here. I don't do Roman numerals, I'm sorry. First, the state has propounded the line of sight theory, which is based upon the out-of-state authority that has never been adopted in Utah. It is primarily based upon the decisions of courts in Pennsylvania before that state enacted a moratorium on the death penalty, which is just another fun fact the defense wants to throw in there. Here's another state that doesn't kill people when they get caught killing someone. Moreover, the state's reliance on this authority fails to support the application of a line of sight formulation to the facts it presented at the preliminary hearing. The state's line of sight theory, as applied to the questioner to the east and below Mr. Kirk, fails based upon the facts the state presented to this court, and no further reasonable inferences are based upon those facts can support that basis for the aggravator. They're saying because of the evidence the state introduced about the scene and where people were, you can't say that the questioner who was filming and standing right in front of Charlie Kirk, sort of in line with everything, was at risk because the 68-foot elevated position, the vantage point. The second theory is an everyone near argument, which relies upon only one of the three factors identified in Sosa Hurtado and ignores the other two factors which are not present here. Moreover, the state asks the court to speculate about the shooter's knowledge. I think you have to do that if you're charging them with knowingly. Even assuming that one can infer a knowledge of some risk to the shooter, the state has failed to show the actual conduct created a high probability that someone other than Mr. Kirk would be killed, and thus this theory fails as a matter of law. Where there were people in some proximity to a discharge of a single projectile from a precision firearm with a high-powered scope, which the evidence establishes hit its intended target, a single factor of proximity fails to permit an inference of a subjective knowledge of the shooter of a high probability of risk of death to others. Where no other person was injured in a manner creating a great risk of death and no other shots were fired, the allegation of KGRD aggravator cannot be sustained. I wonder if there's another aggravator that the state can introduce or change. If basically, can they change the charge? Can they get to death penalty on a different aggravating fact? The state broadly argues that certain individuals were in the shooter's line of fire. There are two fatal flaws in the state's argument. One is factual and the other is legal. Factually, the line of fire assertion as to the questioner defies logic. The evidence established that there was one shooter on the roof of the Losi Center. Mr. Kirk was seated under a pop-up tent in the center of a courtyard to the southwest of where the shooter was, positioned on the roof. The single shot fired traveled from east to west at a downward slope into the bottom of the bowl where the tent was located. See the video at 35, State Exhibit 8, showing the crowd at increasing elevation to the east of the pop-up tent. And in State Exhibit 3, Exhibit 7 also shows the vantage behind the questioner prior to and at 12:23:28 p.m. The questioner is in front of Mr. Kirk to the east. If the questioner had been in the line of fire from a bullet moving towards Kirk, the questioner would have been struck by the bullet as it traveled. Whoa! You don't want to make this argument. It could have barely missed him. In fact, the state's evidence shows exactly why the questioner was not in the line of fire. The single bullet came from above. The video evidence shows that Mr. Kirk was seated on an elevated platform and separated from the questioner by a security barrier, a grassy area, and then tables that surrounded Mr. Kirk on three sides. The bullet traveled at a downward angle and hit Mr. Kirk on the left side of his neck. Where Mr. Kirk's head and neck area was elevated and an unidentified distance away from the questioner, certainly more than a few feet, the only evidence present supports that the bullet traveled above, not through the crowd. I think it's safe to say yes, but how much above is a factor that can be argued. This court must also reject the legal theory behind the state's factual argument. The state asks this court to adopt its interpretation of out-of-state authority on a line-of-fire theory. However, a thorough examination of the cases which construct the line-of-fire theory are not as the state suggests and support that this court should not expand Utah's KGRD application. They like to put it this way, saying the court would be expanding the application of this law, basically telling the judge, you would be creating law where we have not gone before if you do this. If you allow this, it's going to be, you'll be the first one. And judges don't like to break ground. They don't like to break trail and pave a road where no one has gone before, because that's where appeals run rampant. In Commonwealth v. Watson, the Pennsylvania Supreme Court considered the application of Pennsylvania's grave risk aggravator to a case in which Watson fired 3 shots into an occupied car, striking an individual twice. Watson then shot the lock off the door of a home, pulled his girlfriend from the closet where she was hiding with her 2 children, and shot her twice. He then reloaded, left the room, returned, then shot her again, and then shot himself. One of the shots lodged in the door frame around the closet where the children were hiding, but did not hit them. Under these facts, the Pennsylvania court affirmed the jury's finding as to KGRD aggravating factor because the children in the closet were endangered by his conduct. I would suggest that in the response to this, which the state has, I believe, 2 weeks to file, in the response to this this written closing, the state is going to include a lot of other case law situations that aren't the two extremes that the defense is including. Defense wants to say that it counts when you stand up in church and spray bullets all around you from your gun. That's knowingly creating a great risk of death. But if you just, only shoot one person and nobody else gets hurt, then it doesn't. I believe there are probably case law all over in the middle area and possibly on the extremes that the defense might be avoiding purposefully to try to make their argument. The state needs to find those and cite those. In Sylvia v. State, the defendant argued that there was no competent substantial evidence to support KGRD because the gunfire was intended only for one person. The Florida Supreme Court disagreed because Sylvia engaged in indiscriminate shooting of the direction of at least 4 persons other than the intended victim, who were not only put in immediate and present risk of death, but were also in the line of fire. One of the other individuals was shot, and the defendant pumped the shotgun and aimed it at 2 others. The state calls this a few feet, but it's brief. There is no evidence of the distance submitted to the court. The video shows the distance that speaks for itself. So the court explained, "We therefore conclude there was competent substantial evidence that Sylvia's actions created a great risk of death to many persons. He approached the house while pumping shells into his shotgun. Pellets hit one of the cars in the carport, different locations in the carport, and the door from the carport to the house. Pellets were found inside the house in the kitchen, the dining room, and the bedroom. There were 6 unarmed people in the carport and house when Sylvia approached, shooting and pointing the gun at people." In Commonwealth v. Reed, the Pennsylvania Supreme Court found sufficient evidence to uphold the grave risk aggravating circumstance. Reed had fired multiple gunshots at fleeing children after chasing them in his vehicle. Reed sounds like a piece of work. One of the shots hit a young man in the back, killing him. Less than a week later, Reed killed another individual with the same weapon. The court noted that 12 to 14 others were in the line of fire when Reed chased the boys while driving his car, and gunfire flashed from the windows of Reed's car, killing the first victim. In Commonwealth v. Buck, the court considered whether the Commonwealth's notice to the defendant of the aggravating circumstance was sufficient, and if the Commonwealth abused its discretion in proceeding on 3 aggravators. One of them grave risk. In finding the Commonwealth did not abuse its discretion in alleging grave risk, the Buck court found that the evidence raised a factual question for the jury because while only one individual was shot and killed, the potentially endangered person stood behind the decedent in a bathroom, and importantly, because the endangered person wrestled with the defendant over the gun after the shot was fired. In State v. Wood challenged the application of KGRD in a double murder case where he did not shoot any persons other than the victims, and there were no bystanders in the line of fire. The court found that although the defendant's argument had merit, the interpretation of knowingly creating a great risk of death proposed was too narrow. Under the unusual facts of the case, the Wood court found no single factor is dispositive of KGRD, and the inquiry turns on whether, during the course of the killing, the defendant knowingly engaged in conduct that created a real and substantial likelihood that a specific person might suffer fatal injury. Thus, the several factors in combination supported KGRD. There was the presence of others. The defendant turned to another, and it appeared as if he was going to shoot a third individual. Another employee fought defendant over the gun, and there was evidence the defendant knowingly prepared to fire the gun when he assumed a shooting stance towards one employee and then grappled with another. None of these cases support the state's position here. Each involves conduct directed at the endangered person, consistent with the Utah Supreme Court's endorsement of the 3 zone of danger factors in determining if KGRD applies. As a matter of law, this court must consider if any conduct constituting a great risk of death was directed at any individuals other than the victim. Here, there is none. Utah has never adopted an interpretation of KGRD that would permit its application where the firing of a single shot at an intended victim that hit only the intended victim merely because other people were in the vicinity. Nor does the state's reliance on out-of-state authorities, in which personas other than the decedent are targeted and injured, support this proposition. As a matter of law, the court cannot bind Mr. Robinson over on this theory of the KGRD aggravator based on the facts presented by the state. The state's anyone near argument similarly fails both factually and as a matter of law. You can't say that it was KGRD because people were near. The state's argument in support of KGRD aggravator is that the shooter knowingly created a great risk of death to everyone near Mr. Kirk. When a single shot was fired, the state's argument here also fails because it requires the court to speculate in the absence of evidence that would otherwise permit reasonable inferences. Moreover, the state's argument fails again as a matter of law because the conduct here fails to satisfy any of the three factors the Utah Supreme Court has held must be present in order for the KGRD aggravator to be pursued in a manner which does not violate the defendant's constitutional rights under the 8th and 14th Amendments. Number 1, knowledge. That's a loud car. The state asks this court to make a finding that the shooter knowingly created a high probability of a grave risk of death based upon speculation that is not supported by the evidence. The state speculates and asks this court to speculate that the shooter actually observed a security personnel standing an unknown distance from Mr. Kirk, that the shooter may have known that there were people behind the pop-up tent when the single shot was fired, although the state's evidence actually shows otherwise, that the shooter knew that they may strike someone other than the intended target because there were 4 cartridges found in the rifle, and that the shooter knew that they may strike someone other than the intended target because targets with bullet holes in them were recovered from Mr. Robinson's shared apartment, or that the shooter knew that they may strike someone other than the intended target because the rifle may have been taken apart and put back together. These assertions are not reasonable inferences from the evidence actually presented and, in one instance, are actually inconsistent with the evidence before the court. The evidence does not support that the shooter acted knowingly. That is, the shooter was aware that there was a high probability that somebody else may die from his single gunshot that hit the intended victim. As to A, the state's evidence shows that the presumed shooter was on the Losi Center roof in a prone position for approximately 35 to 44 seconds before firing the weapon once. This is funny because they have to keep saying the presumed shooter. They never want to say that my client didn't do that. He only shot 1 round. They don't want to admit anything. So they're always trying to couch their argument in the alleged person supposedly did this. Makes it fancy speak. But they're basically dodging admissions. According to state's evidence, this means the shooter had approximately 40 seconds after coming to rest to ready their rifle, acquire the target with the scope on their rifle, steady their breathing, and fire the weapon. The state asked the court to speculate about what the shooter saw through the scope during this limited window of time while focusing on these tasks. However, one of the state's case agents, Agent Hull, testified that he could not testify as to what the shooter saw. I think you can infer that he didn't just set up the rifle, immediately pointed at Charlie Kirk and looked down and pulled the trigger and then took it down and didn't point at anyone else. I think that's a reasonable inference that the loaded gun was pointed at someone else. We believe it was loaded. Indeed, the only reasonable inference from this limited time window and the fact that Mr. Kirk was shot was that the shooter observed Mr. Kirk through his scope. As to B, the state's assertion that the shooter should have known there were individuals behind the pop-up tent is not a reasonable inference supported by its own evidence. In fact, State's Exhibit 9 shows no one directly behind where Mr. Kirk was located when the single shot was fired. There's no one stood in the middle behind the tent. Moreover, the shooter could not, of course, see the tent through the tent and again was on the rooftop vantage for only 35 to 44 seconds before taking a single shot with a high-powered rifle with a precision scope attached to it and then immediately fleeing back to the back of the rooftop area. It's possible that if we have additional video of the alleged shooter speaking to the TPUSA people, if they were in that position, if they were down there setting up the booth, if they were putting up the tent and everything else, that he would have seen people behind the tent then. But the space in time between when he was talking to them and when the shooting occurred was probably be too great to count that. The state relies on surveillance footage from earlier in the day to suggest the shooter had knowledge there would be... Oh, I should probably read ahead. The shooter had knowledge that there would be people behind the pop-up tent during the event. The state's evidence is that Mr. Robinson was on campus at 8:30 a.m. and went to the amphitheater at that time, 3.5 hours before the event began. The state asked the court to speculate that the amphitheater and the people around it looked to the shooter at the time just as it did 4 hours later when the shot was fired, which obviously it didn't. The crowd wasn't there yet. As depicted in Exhibits 6, 7, 8, and 9. There is no evidence from which the court can make such an inference, and again, the evidence is the shooter had an extremely narrow window of time to observe the intended target through the scope of the rifle. The only reasonable inference that can be drawn is that the shooter saw the intended target. As to C, the state asked the court to speculate about the shooter's knowledge that he was creating a high probability that someone else could be killed because the recovered Mauser 98 had more than one round of ammunition in it. This is a circumstance in which the state cannot prove one inference is more likely than any other, and thus asking the court to speculate. It is just as likely that the shooter did not believe he would miss as it is that the shooter believed as the state speculates. Having a loaded weapon does not mean the individual believes there is a high probability of missing and killing someone else. It only means that they have the ability to fire more than one round. The facts here are the shooter did not miss his intended target and did not chamber another round, leaving the spent cartridge in the rifle. But the engravings on the other bullets, and only on the bullets that he brought there, and not on the rest of his bullets back at home, could argue against that, I think. The state argues the targets taken from Mr. Robinson's apartment support an inference that Mr. Robinson used the targets in connection with the shooting at UVU and therefore knew of a high probability of risk of death to others. However, this court cannot reasonably infer that Mr. Robinson's alleged use of the targets at some point in the past with some unknown weapon led to such knowledge on this part. The state presented no evidence of when the targets were used, what weapon was used with the targets, the conditions under which the targets were used, or even that Mr. Robinson was alone in shooting at the targets, or that all the targets were fired at by him. Without any evidence tying the targets to the seized weapon, the relevant time frame, the conditions under which the targets were used, and the targets are not a basis for any reasonable inference about the shooter's state of mind. As to E, the state also asked this court to speculate that after scoping the rifle, it was taken apart and put back together prior to the shooting, and that therefore the shooter knew that a lack of accuracy created a high probability of risk of death to others. The state presented no evidence to support any inference that the rifle was in pieces at any time. The video evidence shows Mr. Robinson walking up and down the stairs at UVU with a gait impaired by something long in his pant leg. The reasonable inference from the evidence provided is that it was a fully assembled rifle. The presence of a screwdriver on the roof does not establish that the rifle was taken apart and put back together any more than it establishes that the screwdriver was intended to take the rifle apart after the shooting. The state did not present any evidence as to how the screwdriver could have been used to disassemble and reassemble this weapon in the period of time at issue. Even if the court draws the inference that there is a connection between the rifle and the screwdriver, the court cannot then reasonably infer that inference that a rifle deconstructed and then reconstructed would be less accurate, let alone that a shooter knew of that risk. But I think an expert could testify to that. You would have to show that he knew, though. I know just from taking scopes off my gun and putting them back on, even with quick release mounts, that you have to re-sight them in. Presence alone is insufficient as a matter of law to show knowingly creating a great risk of death. Even assuming... there's a word I don't know. Arguendo? Even assuming arguendo, I think it's an argument, that the shooter had knowledge that there were other individuals near Mr. Kirk, this fact alone does not satisfy that there was a great risk of death to another. The state relies on cases from Pennsylvania for the assertion that a zone of danger encompasses everyone near a shooting victim. As noted above, Utah has never adopted a formulation of arguendo. Thank you, Red Pen, for that. Utah has never adopted a formulation of KGRD under which a single gunshot fired at a specifically identified target who was near others is sufficient to establish KGRD. Moreover, the cases cited by the state from Pennsylvania, again, do not support its position as explained below. In Commonwealth v. Rios, once back in PA again, 3 assailants entered a home to commit a robbery. The residence was occupied by 4 individuals. 2 of the individuals were beaten and multiple firearms were involved. All 4 of the victims were forced to lay down either on a bed or on the floor in a single bedroom, and one of them was shot and killed. The court found that the facts presented at trial supported the KGRD finding because the fatal bullet was fired while the victim lay on the floor of an enclosed bedroom, with one individual on the floor close to the victim and the others on the bed nearby. The court in Commonwealth v. Lee upheld the finding of grave risk when 3 assailants with multiple firearms shot one individual in the head inside the kitchen of a restaurant while the murder's victim's sister was standing directly next to her. In Commonwealth v. Smith, the Commonwealth presented medical and forensic evidence to demonstrate grave risk of death to another person. The evidence demonstrated that 4 shots were fired by the defendant. The first shot fired hit the victim, who fell but then tried to get up. Therefore, the defendant fired 3 more shots at the victim. 3 of the rounds lodged in the victim, while a 4th passed through. One of the bullets fired at the victim ricocheted off a solid surface before hitting the victim. There were several people on the porch in very close proximity to the murder victim. The Pennsylvania Supreme Court affirmed the finding by the jury on these facts. In Commonwealth v. Wright, the evidence supporting grave risk was that Wright broke into a small bedroom while swinging his loaded gun in all directions. He put his gun to the victim's wife's head. Once finding the victim, Wright fired 5 shots at him, 3 of which went through him, and 1 of which was never located. The victim was only a few feet from the bed on which the child was lying. Shell casings were found all over the bedroom. Wow, that spells that case out a little bit. Pennsylvania court determined that under these circumstances it was proper to leave the grave risk of danger determination to the jury. That means it's acceptable to charge that. The significant factual differences between these cases and the case before this court are plain. The bullet that struck and killed Mr. Kirk was not fired in an enclosed bedroom or space, but rather an open-air arena with what the state's witness termed a clear line of sight. There were no threats to others in the course of conduct. A clear line of sight can be extremely narrow, as long as you can just see all the way there. There was no one directly next to Mr. Kirk when he was shot, and there was no one under the tent on the side that Mr. Kirk was struck or behind him in the breezeway. Multiple shots were not fired. There were no ricocheting bullets. These cases from a state with a moratorium on its own death penalty are not Utah law and do not support the state's call for this court to adopt out of state authority that vastly expands Utah's KGRD aggravator beyond its constitutionally narrow application, as explained in Sosa, Johnson, and Pierre. Okay, they're saying, yes, Pennsylvania lets them use this aggravator in these cases, but it's not Utah law. So don't use their citations to say, yes, you should do it, because it's different jurisdiction. Utah law requires this court to look at more than mere presence to determine if there's a high probability, not a mere possibility, that another would be killed by the shooter's conduct and the shooter knew of that high probability. A plenary of jurisdictions support Utah's narrow construction of KGRD. So now that they've said don't use other states' laws to decide what Utah should do, now they're saying what other states' laws are to tell Utah what to do. Many of the jurisdictions have interpreted KGRD as the Utah Supreme Court has, a multi-factor analysis that examines the course of conduct of the defendant and actions towards the another in determining both the defendant's knowledge and the probability of risk. For example, Oklahoma has determined that evidence is sufficient to support KGRD where the defendant created a great risk of death in close proximity in terms of time, location, and the intent to the killing, or threatened the life of another and had apparent ability or means of taking that person's life. In rare instances where the person at risk was not actually injured, defendants in those cases seriously considered killing people other than the actual victims. In the Oklahoma case of Little John v. State, the court considered the sufficiency of the evidence supporting KGRD. the court found the evidence was insufficient to support KGRD aggravating factor where the prosecution presented no evidence that the defendant considered injuring anyone other than the actual victim. Although defendant pointed a gun at a clerk when he was asked for the store's money, this act was driven by the defendant's intent to rob. Additionally, only a single shot was fired, and it hit its intended victim rather than endangering anyone else present in the store. As summarized, this is not a case where the defendant shot wildly into a store or a crowd. Only one shot was fired. The shot hit its intended victim. The single shot did not endanger anyone else present in the store. Consequently, under the specific circumstances of this case, we find the evidence was insufficient to prove Little John knowingly created a great risk of death to more than one person. Now we've got Brechin versus Reynolds. It rejects the Eighth Amendment vagueness challenge to KGRD because reviewing Oklahoma case law, Oklahoma courts provided consistent guidance to the jury so as to limit its discretion. The Wyoming Supreme Court upheld KGRD in Engbird versus State. You don't get many Wyoming citations on case law, probably because they only have like 200,000 people that live there. They concluded, in shooting errantly at persons in parked vehicles in the lot, Engbird manifested an utter disregard for lives of innocent persons. This evidence demonstrated beyond a reasonable doubt that Engbird knowingly created a great risk of death of two or more persons. Let's see. Later, Olson v. State in Wyoming addressed another bystander case. The Olson court noted the state failed to produce evidence or suggest that there were other bystanders involved who were threatened with grave harm as Olson shot his intended victims. Thus, strictly construing the Wyoming statute, the Olson court found the use of the terms risk and persons was given its proper application in Engbird's factual situation by placing bystanders in a parking lot at great risk of death by errant shooting. In the Alabama case of White v. State, the appellate court upheld the finding of KGRD where the defendant indiscriminately fired a shotgun into an occupied dwelling containing not only the victim but two other people, and the defendant fired the pistol out in front of the yard in a residential neighborhood where many other people were present. The court found the defendant's conduct and the indiscriminate firing of these weapons did in fact create a great risk of death to many other people. Finally, there is also an almost identical federal statutory aggravator. The defendant, in the commission of the offense or in escaping apprehension for the violation of the offense, knowingly created a grave risk of death to one or more persons in addition to the victim of the offense. In United States versus McVeigh, is that Timothy McVeigh? Yeah, it's Colorado. The Oklahoma City bombing case, yep. The district court found the inclusion of KGRD in the indictment was proper where the government intended to prove the truck bomb was of such force to create a great risk to persons who were not physically affected by the explosion. Similarly, in United States versus bin Laden, wow, we're using all the citations now. Wyoming has 588,753 people in it, by the way. Congratulations. You still have more antelope than people. I like Wyoming. It's beautiful. Spent many beautiful summers up in the Wind River Mountains. All right. In the bin Laden case, another bombing case, the district court sanctioned the inclusion of KGRD as an aggravator, noting KGRD relates to defendant's mental state with respect to persons who were not intended victims of the bombings. The bin Laden court noted there may be a qualitative difference between the defendant who carefully targets an intended victim or victims without endangering others and one who acts with indifference to additional persons. These examples are non-exhaustive, but illustrate how other jurisdictions have interpreted KGRD consistently with the Utah Supreme Court. These jurisdictions all require close examination of the defendant's course of conduct and the mental state of the defendant relative to other individuals. Little footnote, State v. Johnson upheld the jury's finding of KGRD where the defendant shot a law enforcement officer multiple times and a bullet struck a juvenile standing next to the patrol car. In State v. Hazelton in Kansas, upholding KGRD where the defendant lured two victims to the woods, intended to shoot both, shot one victim, and shortly thereafter shot the other victim, demonstrating a course of conduct. And State v. Carver out of North Carolina, the trial court did not err in finding KGRD close examination of the defense course of... Oh, that's it. Just didn't find KGRD. Where the defendant fired multiple shots in a crowd of people with a semi-automatic rifle capable of firing 8 bullets without being reloaded. Johnson v. State in Tennessee, we declined to adopt a per se rule that would automatically allow this aggravating circumstance in all felony murder cases where the defendant is armed with a pistol and others are present. That's probably the best way to put it. You can't just automatically make it an aggravated murder just because you have a gun and other people are there. Such a per se rule would not adequately provide for individualized sentencing, and it would unnecessarily broaden KGRD to a point where it would fail in its essential function as narrowing the death-eligible class. In Porter v. State in Mississippi, evidentiary basis insufficient where the defendant hired to kill the victim hid outside the doorway of the victim's home and shot him when he came to the door, fleeing afterwards despite the fact that there were other persons in the house. In State v. Sandoval in Nebraska, 3 men with semi-automatic handguns entered a bank full of people and fired at the people in the bank. The 3 survivors were within range of Sandoval's weapon at all times, and he unquestionably placed them at great risk of death. Count 6 must be stricken because the evidence does not establish that Mr. Robinson's statement to Mr. Twiggs to ask for a lawyer and stay silent was intended to obstruct an investigation. Count 6 charges Mr. Robinson with tampering with a witness in violation of Utah Code. The information alleges that Mr. Robinson committed this offense by directing his roommate to stay silent if police questioned the roommate. The state alleges that by telling Mr. Twiggs to exercise his right under the Fifth Amendment to the United States Constitution to ask for counsel and to remain silent, Mr. Robinson attempted to introduce or otherwise cause his roommate to withhold testimony or information with the intent to prevent an official proceeding or investigation. Count 6 must be stricken because Mr. Robinson's advice to Mr. Twiggs is consistent with the long-standing constitutional principle that every person in this country has the right to remain silent. In the fact of government interrogation, and because the context in which the allegedly improper statement was made demonstrates that it was purely altruistic and for Mr. Twiggs' benefit rather than for the purpose of obstructing an investigation. While the influencer's motive in advising another to remain silent is to impede the investigation against him, rather than give purely altruistic advice, he is obstructing justice. We read that part already. In United States v. Peterson, the inverse is therefore true. Where the advice is purely altruistic, one is not obstructing justice. Mr. Robinson's advice to Mr. Twiggs was as followed, and I quote, "If any police ask you questions, ask for a lawyer and stay silent. My lawyer should be Doug Terry. I'll see if he can reach out to you, and make sure the police follow the right procedures, proper warrants and stuff, but be polite and respectful, of course." Whether an individual who is under investigation is obstructing that investigation or providing truly altruistic advice to another requires a context-specific analysis. Here, the conversation between Mr. Twiggs and Mr. Robinson demonstrates Mr. Robinson's focus was on protecting Mr. Twiggs from any fallout from the events which had transpired, and not on him inducing him to obstruct an investigation. Here he says to Mr. Twiggs, and we quote once again, "I'm going to turn myself in willingly. One of my neighbors here is a deputy for the sheriff. We hope to keep things sort of quiet here." Yeah, that didn't work. "I only hope they let you visit. I'm going to miss you. Please be good for me. If you need anything at all, both of my parents are willing to help you. Please go to them. Leave the room alone. The feds will search it top to bottom for certain, then work with my family to sort it out, what goes where and such." In response to Mr. Twiggs' question, "Is there any way you don't go to prison?" Mr. Robinson responded, and we quote once again, "I highly doubt it. I will update you as much as I can. If you need a place to stay, I'm sure my family would have you in my old room. You are all I worry about, love. Don't talk to any media, please. Don't take any interviews or make comments. I will always love you. I will write to you as often as possible. If any police ask you questions, ask for a lawyer and stay silent. Make sure the police follow the right procedures, proper warrants and stuff. Be polite and respectful, of course." These statements by Mr. Robinson contextualize his altruistic advice to Mr. Twiggs to exercise his rights under the Fifth Amendment. Ohio Palm Bomb, thank you very much. Happy birthday. I'm catching up 3 times now. It's wonderful. It's good stuff. Thank you very much for the birthday wishes for the channel. Altruistic advice to Mr. Twiggs to exercise his rights under the Fifth Amendment to ask for a lawyer and stay silent. The facts do not support the state's allegation that this statement by Mr. Robinson was made with an intent to prevent an official proceeding or investigation. Count 6 must be stricken. Count 7 must be stricken because the evidence does not establish that Mr. Robinson had knowledge that a child under the age of 14 was present and would see or hear the commission of the charged homicide. The information charges Mr. Robinson in Count 7 with substantive offense of knowingly exposing a child under the age of 14 to the charged homicide in violation of Utah Code. Apparently, once you're 15, Utah thinks you can watch murders. This section of Utah law requires that the state prove that a violent offense occurred in the physical presence of a child younger than 14 years old, with the defendant having knowledge that the child is present and may see or hear the commission of a violent offense, criminal offense. The state has failed to present sufficient evidence to establish probable cause that the Robinsons did in fact have the requisite knowledge. While the state presented a video which shows two children, in fact, present at the TPUSA rally on September 10th, the state presented no evidence that the shooter was aware of the child's presence, nor that he was aware of the presence of any other child under the age of 14. Without any evidentiary support, the state invites the court to speculate that Mr. Robinson, from approximately 400 feet away and during a 35 to 44-second period, came to be aware of the presence of children under the age of 14, relying upon Mr. Robinson's alleged walking tour of the campus hours before the TPUSA rally began. There was no evidence that Mr. Robinson was anywhere near the crowd that formed prior to the rally, or that he observed children or families with children making their way to the space where the rally occurred. Indeed, the path Mr. Robinson traveled was as visible in the state's exhibits 12.1 and 12.4, suggests that Mr. Robinson did not even pass anyone that could be identified as under 14 years old. The reasonable inferences might differ if the location of the incident were not a college campus. If a defendant were to engage in crimes of violence on an obviously occupied elementary school or a daycare facility, it might be reasonable to infer the knowledge required under Count 7. With the evidence as it is, this is not a reasonable inference. All right, I'm going to need some a wee break. We're going to do a Quaker granola bar break. It's not a Snickers, but it'll have to do because I don't have any Snickers. I think we're going to end the stream with cake.
When are we going to break for lunch, Judge?
Take a short break.
All right.
You wear multiple hats, sir.
I do. All right. A, the violent offense committed in the presence of a child, aggravating factor, must be stricken for the same reason. There is no evidence that Mr. Robinson had the requisite knowledge. Separate and apart from Count 7, the state has alleged the identical aggravating factor in connection with the Counts 1 and 2 pursuant to the Utah Code, Section 76.3.2039. The analysis is no different. There's no evidence that Mr. Robinson had the requisite knowledge, and the state improperly invites the court to speculate. An inference is a conclusion reached by considering other facts and deducing a logical consequence from them. And speculation entails the act or practice of theorizing about matters over which there is no certain knowledge at hand. The state's backdrop position that sentencing enhancements are not subject to proof at a preliminary hearing is inconsistent with well-established constitutional law. This is interesting because if the state fails on this front and they lose the death penalty in this case, there'll be a lot of egg on their face for Mr. Ballard and his team. Mr. Ballard, who is the state prosecutor who has already been held in, did the show cause hearing and found to have been in contempt with the rules of the court as far as talking to the media, has been nominated by the governor to be like on the Supreme Court of Utah or something like that. Some huge position. So interesting. We'll see if this backfires on them. The state asserts that the enhancements alleged in the information are not subject to this court's review in a preliminary hearing. The state is incorrect about this important matter and relies on an invalidated distinction between elements and sentencing factors. While the Utah Supreme Court did so hold in cases in the 1970s and 1980s, in the year 2000, the United States Supreme Court squarely held that any fact which increases the potential punishment in a case, other than criminal history facts, are elements for the offense which must be proven to a jury beyond a reasonable doubt. But that's at trial. We're talking about preliminary hearing here. There's no jury at a preliminary hearing. In fact, the court wrote, "It is unconstitutional for a legislature to remove from the jury the assessment of facts that increase the prescribed range of penalties to which the criminal defendant is exposed. This is equally clear that such facts must be established by proof beyond a reasonable doubt." I don't know why they're making this argument. It doesn't make sense. Here, the state has charged Mr. Robinson in information subject to a probable cause determination with two separate sentencing enhancements, each of which carries the possibility of increasing Mr. Robinson's punishment. 76.3.203.9 requires the sentencing court of the Board of Pardons and Parole to consider whether the knowing presence of a child enhancement has been proven in the course of exercising their authority over sentencing and release decisions. 23.14 is a victim targeting enhancement, which makes one classification higher to the offense for which the defendant was convicted. Therefore, it too is subject to apprendi. Where the state has elected not to proceed by way of grand jury, but instead elects to present the evidence in support of its information to a magistrate with a preliminary hearing, the defendant's constitutional right not to be tried on any of the charged offenses absent an initial finding of probable cause extends to enhancements that increase the potential punishment. Okay, so here they're saying you didn't do a grand jury, because Utah doesn't do many grand juries at all. They can, legally. It's possible to do them, but they generally don't. And I like that, because grand juries are secret, and it's all one-sided, and it's slanted and everything else. And a grand jury wouldn't dine a ham sandwich. They instead went with the judge with a preliminary hearing, the defendant's constitutional right not to be tried on any of the charged offenses absent an initial finding of probable cause, extends to the enhancements that increase the potential punishment. So they're saying you can't send someone to trial on a charge that wasn't first covered by the preliminary hearing because you chose not to do a grand jury. If a grand jury had indicted on that, then you could go to trial on that. You chose to do a pretrial hearing on this charge with aggravated murder, so we have to have the murder charge addressed in the preliminary hearing as well as the aggravated part. You have to basically address them both, which means you have to prove the aggravator in the pretrial hearing is their argument. Let's see. This is the logical consequence of apprendi, which eliminated, with exceptions not applicable here, the distinction between elements of an offense and sentencing factors which increase the maximum punishment. The state must prove each of the enhancements to this court, sitting as a magistrate, by probable cause. As to the violent offense committed in the presence of the child, Mr. Robinson has explained above why the state has failed to meet its burden of proof. Mr. Robinson now turns to the second enhancement alleged in the information, an allegation that Mr. Robinson selected Mr. Kirk based on Mr. Robinson's views of Mr. Kirk's political expression. This might be an easier one to prove, but the law here is it's very tricky. The state has failed to produce reliable evidence that the victim targeting enhancement applies here. The victim targeting enhancement under Utah Code is focused on the defendant's perception concerning a personal attribute of the victim. The single personal attribute alleged in the information is Mr. Kirk's political expression, without any further specificity in the charging document. In support of this enhancement, the state proffers two disconnected sets of facts which fail to establish probable cause. One set is Exhibit 5.1, Rule 1102, witness statement of David Engelhart, a pastor. Pastor Englehart's statement contains no information concerning Mr. Robinson's state of mind as to Mr. Kirk's political expressions. While it purports to present this court with information as to what Charlie Kirk believed, as all the theologically orthodox Christians believe, about gender identity and sexuality, it does not identify any specific statements made by Mr. Kirk on these topics prior to September 10th, 2025. It also identifies subject matters that Mr. Kirk would debate and discuss at various events, but does not identify a specific political expression of Mr. Kirk on such topics, let alone statements of Mr. Kirk that were both known to and motivated Mr. Robinson. Therefore, Mr. Englehart's written sermon as to what all theologically orthodox Christians, including Mr. Kirk, believe, does not establish that Mr. Robinson intentionally selected the victim of criminal offense because of the defendant's belief or perception regarding the victim's personal attribute or a personal attribute of another individual or group of individuals with whom the victim has a relationship. That's a long sentence. The only other fact is that Mr. Robinson's statement to Mr. Twiggs, quote, "I had enough of his hatred." Mr. Robinson does not tell Mr. Twiggs in this exchange, nor was there, according to Mr. Twiggs, any prior communication between them concerning Mr. Kirk, nor that Mr. Robinson targeted Mr. Kirk because of his religious beliefs, or his political beliefs, or any other category of beliefs. He refers to hatred and nothing more. Ironically, it is the state that argues that because of Mr. Robinson and Mr. Twiggs are two men who love each other, and or it speculates because Mr. Twiggs, and not Mr. Robinson, was at least intermittently identifying as a female to his close friends, it is Mr. Kirk's views on these topics which the hatred Mr. Robinson was referring to. These circumstances are not sufficient to establish, even by probable cause, which, if any political expression of Mr. Kirk motivated Mr. Robinson to select Mr. Kirk for an act of violence. Okay, we've got Amber on the phone. Hey, Amber, you're live.
Yeah, and you're missing buffers.
I just got one.
Uh-huh. Okay, goodbye.
Okay, bye. Let's see. We've got a verdict in the Simmons case, so we have to go back just a little bit. How far back? I know not. Let's see. Go to channel. She's live.
Get you downstairs to the Treasury office, I think, in the next 25 minutes anyways. But if you would like to stay back and give some feedback, ask some further questions, they can meet you in the jury room. But thank you again.
I missed a lot of it. Hang on. Waiting for them to come in. I think it's here. 2 minutes.
Mr. Burkhardt?
Good afternoon, Your Honor.
This is not it.
You don't see what? Any servers? Let me see a second.
Why does it skip like that?
Delivery to a member of the
Okay, all rise for the jury.
That's it. It just says all rise for the jury.
Household of suitable age and discretion that occurred August 8th at 8:39 p.m.
Okay, you can submit default.
Okay, thank you, Your Honor.
Thank you. Mr. Williams, you're all set, I believe.
Thank you.
Thank you. All right, for the jury.
That's it. That's all we get.
Mr. Schoen, that's all we have for today. Thank you.
Have a rest of your day, Your Honor.
All right, we're going to pause just for a second. In the case of sister against sister, they say blood is thicker than water. And these 10 kids, they didn't all get along. At least 2 of them didn't. And what happened on that day, in 1 minute and 47 seconds in the front room of the home, the family home, only the jury will know. But they're going to tell us here in just a minute as they come back from deliberation. Deliberation, by my count, was like 3.5, maybe 4 hours. It was so long for a case that altogether probably only took 2 hours. So we'll fade this out and let's hear what
That
they
you
say.
do have a unanimous verdict. Is that correct?
Yeah.
You are you the court
I
person?
am.
Okay, you can read the verdict.
Okay, so, do I say like we the jury?
Yeah.
Okay.
This is your moment.
Alright, here we go. Okay, so we the jury find the defendant not guilty of, do I say what it is?
Yes.
Assault or assault and battery.
Did you want the jury polled?
No, thank you.
Did you want the jury polled?
No.
Okay, I will say this. I think this is probably a record for how long I've had a jury deliberate. So that is a testament to the work that you all are doing back there. It also is a testament that when the blood sugar hits the brain, like I said, they'll come to a verdict. That's the second time we had that happen. Right shortly after the food got there, the verdict came. But we thank you again for appearing, for being diligent and being attentive and being willing to do the work that's necessary to have justice, the justice system work the way it's supposed to work. So sometimes the attorneys do like to get feedback. That's totally up to you if you want to stay back to do that. I do have to advise you though that we got to get you downstairs to the Treasury office, I think, in the next 25 minutes anyways. But if you would like to stay back and give some feedback, ask some further questions, they can meet you in the jury room. But thank you again, and you're free to go.
All right, that's all we need right there. Not guilty. It didn't happen. It wasn't me. It wasn't me. All right. Thank you very much for letting us catch that, Red. Thanks for learning us. We're going to go back to reading the document from Tyler Robinson. I am going to ask, let's see, what page are we on? On page 32 out of 41. So we've got 9 more pages. We can do this. We're going to finish this up. The last few pages, I think, are a little shorter. These circumstances are not sufficient to establish, even by probable cause, if any political expression of Mr. Kirk motivated Mr. Robinson to select Mr. Kirk for an act of violence. There is no evidence of specific political expressions of Mr. Kirk, which, if any, Mr. Robinson may have been aware of or focused on. There are no writings attributed to Mr. Robinson on this topic. There are no statements by Mr. Robinson to third parties which address Mr. Kirk or his political viewpoints and Mr. Robinson's perception of them. After searching his residence, his parents' residence, his computers, his telephone, Mr. Twiggs' telephone, and hundreds of law enforcement interviews, there is nothing to base this sentencing enhancement upon other than that single criticism of Mr. Kirk's hatred. In the face of the absence of evidence, the state focuses on Mr. Robinson's sexuality and Mr. Twiggs' gender identity. If only because those are two topics on which Mr. Kirk was, in fact, widely viewed as expressing hatred and intolerance. However, that is not an evidentiary substitute for proof that Mr. Robinson targeted Mr. Kirk because of those exceptions. It is the state's speculation that he did so. The victim targeting enhancement must be stricken. So in conclusion, in relying largely on hearsay, deemed reliable by rule, yes, and by the Supreme Court, the state has failed to prove probable cause by reliable evidence that satisfies each element of each of the charged evidence. For this reason alone, this court must decline bindover. In addition, the state has not provided this court with sufficient evidence as a matter of law to satisfy the sole alleged aggravator in the information. Under controlling constitutional law and Utah Supreme Court interpretation, the court cannot find, based on the state's evidence, that the circumstances presented a great risk of death to another other than Charlie Kirk and himself, and that the shooter knew of this high probability of death of another. Finally, the court should decline to bind over on the state's alleged aggravators and counts 6 and 7, where the state requires this court to speculate in the absence of evidence to establish essential elements. So respectively submitted this day, Kathy Nestor, Michael Burt, Richard Novak, and Stacy Visor. And certified right there by Stacy. She's the one who filed it. It's 41 pages, but only 35, because this one doesn't count, and these ones don't count. See, these are this is the other stuff, which means we're done. We have completed the reading. All we have left is to eat cake upside down in a bowl with milk. I didn't spill my water that whole time. So if you guys have not availed yourself of the opportunity to consume cake upside down in a bowl with milk with a spoon like you would eat cereal. Yes, I know it makes the cake soggy. It makes the cake better. It really does. It is party time because it's the birthday anniversary of the channel, which means I'm going to play some music really quickly while I run to go and get my cake and a bowl of milk, and we'll finish that. Hold on just one second. I'll be right back.
Happy birthday. You look good.
All right, I made it back. Before the song was over. Here it is. Cake upside down in a bowl with milk. I grabbed this out of the fridge, and my wife's like, I don't know whose that is. She's like, wait. That might be for somebody. I said, it is. It's for me. It's good. It's good. I'll finish it afterwards. I cut off the birthday song. It's on the same pad. It's on the same pad as that. I was trying to match them up perfectly. Guys, thanks very much for joining us today. That's going to be the end of it for today. Tomorrow we're going to read what happens to a naughty judge. Naughty judge. Kelsey, thank you for 6 months of support. Happy birthday. Attorney level support as well. Kelsey, thank you. That makes it all possible. course, Recovery Addict is 7 for the show. I'm not sure what a 7 and 7 is. I'm guessing ounces of each, but I'm not sure what they're of. I'm going to eat this. I did spill. My wife said, are you going to tell them that you don't know how to pour milk? I'm not. Tonight, when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe. We go live again tomorrow morning. We've got another reading, a shorter one, but it's a naughty judge who got caught and getting told off. So we're going to read that tomorrow. We're rapidly approaching the beginning of the Keefe D trial, which is going to be a blast to cover. It's going to be great. Fingers crossed. You guys have a great one. I'm going to go take my kids up to some rock climbing thing now. So we'll see y'all. You guys, we get to each other. Mods, thank you very much. You're absolutely amazing. I appreciate all of it. Thank you, Michael Vi. Thank you, Michael Vi, for the sunshine as well. If I missed anyone here, I apologize. I think I got everybody. Sherlock Mel, member for 3 months. Happy birthday to the best channel on YouTube. Thank you, Scott and Mods, fellow watchers, for making this an amazing opportunity. Thank you. Thank you. It wouldn't be the same without cheer. You guys have a good one. We'll see you tomorrow. Bye-bye.
Because he's the guy.
Happy birthday. You look good.